Welcome back to the PI show. Before the break, we were talking with Richard Lightfoot, who is a consulting engineer who's an expert. He's been an expert for 28 years and still going strong. Richard, there's a number of cases. I think Makita's case is the most well-known case about guidelines for experts, but reading Makita's case, it was a woman who slipped on some steps, and they had an expert to say the steps were slippery. How do you determine whether steps are slippery or not?
Well, the Australian standard for slip resistance of pedestrian surfaces is the principal principal reference that you test against, right? You use, for dry slip resistance, a machine called a tortoise. It drives itself across the floor with a 4S rubber, a rubber section about that diameter, like that, and you get from that a printout that gives you the coefficient of friction for the dry surface. Then for a wet surface, you use a Stanley pendulum action. It travels across the surface for a distance of approximately 127 millimetres, and from the absorbed energy you can get what's called a British pendulum number for that, and there have been a series of tests on different surfaces that then give you an indication of the potential contribution of the surface to a slip.
Is the Australian standard the be-all end-all for a slipping case?
Well, it is the best guide we've got, in the sense that a lot of people may come up with other methods of testing, but you've got to have something that's reproducible, in the sense that if Harry had a machine and he tested it, you had another machine and tested it, you'd want those results to come into the same order of magnitude. Otherwise, you're not comparing like with like.
So when you're talking about slipping, it's mainly what? Surfaces where someone spilt water or some other liquid?
Generally, you're looking at a smooth surface initially, then most times you've got to have water or a foreign material on it. Because if you've got a rough surface, I'll use the analogy, it's like mountains through the fog. You've got little grains coming up that when the material on the heel of a shoe hits it, it catches, and therefore doesn't slide. Whereas if it's smooth and you've also got the potential of a foreign material, you'll aquaplane across the surface, right?
And so that causes a fall, cause a fall.
You've also got to think about the size of step a person's taking, if they're hurrying, and also the type of shoes and shoe material as well. Because see, a 4S rubber is designed to be across the board as far as an average is concerned. Otherwise you'd have to test with leather and this compound and that, and you wouldn't know where you were.
Harry, in this case of Makita that you referred to, she failed.
She failed.
After the engineer said that it was slippery.
It was a strange case. The accident happened in 1986. Mm-hmm. The slip test was done 9.5 years later, which throws some doubt upon its viability.
Well, immediately, if you're an expert undertaking that testing, you'd be questioned, is the surface the same?
Yeah,
and you have to say, no, it's not. And as likely as not, it could be wear polished from use. And in that particular case, I think it was established that the workers at that particular location walked over the stairs many times, and even the plaintiff walked over the stairs many times without slipping.
So there's no history. There's no history.
What was on the surface? Was it just?
It was a concrete
surface. Was there any substance on it?
No, not that I'm aware of. No,
okay.
Because as in this particular case, the Judge Hayden said, the lay history of the incident-free use of the stairs suggests that it wasn't slippery.
Yeah, so there's no prior history and no one had fallen either before or after that. The judge said as a matter of common sense it wasn't slippery, no matter what the experts said.
I think you'd be pretty apprehensive as an expert getting into the picture 9.5 years later, wouldn't you?
Well, it's impossible. You've got to say to yourself, when there's that lapse of time, the only way you could look at it would be if there was a section of the stair that you could test that hadn't been worn to the same degree, and that would only then be an indication
Yeah,
So the key
That's
is-
why-
it's a big bit of guesswork.
So as far as you're concerned, you'd like to get involved pretty quick.
I think in any instance, the sooner that you can establish the information, the better off you are, because things like this do change.
Because the conclusion's
It's like
only gonna
factories.
be-
The sort of factories change. People move on. New lines of equipment come in,
And the evidence disappears.
and at times you find that the injured party will come in and say, "Look, it's all changed."
Yeah.
Right?
And that's why in a police investigation, they generally seal the area off and get all the
All the evidence
evidence
straight off.
pretty early in the piece.
We're coming to the AFL season, and again, there are sporting injuries in the AFL. There's peculiar provisions about whether they're covered under the Accident Compact, but Sean Wren sued, I think, the AFL many years ago, again, as a slipping case, and the jarring of a knee or the damage to a
Yeah,
knee.
they put a special rubber in the centre of the ground, Harry, to assist the umpires in bouncing a ball.
Well, in a case like that, once you've changed the circumstance, you've got to do an assessment to see what is likely to result.
So
Okay.
they probably,
And
one of the
maintenance.
faults was not doing a risk assessment or not thinking about what the risk was when you're putting in something where you've changed the surface of a sporting ground.
Well, Harry, I think he slipped because it was rubber and you got the studs of your boots that generally dig into the ground.
But in that case, they didn't do a risk assessment.
No. That raises another interesting point.
Well,
Richard.
again, it's ground maintenance as well. Sporting accidents rely on good ground maintenance and also ensuring that checks are undertaken.
But that wasn't a case of ground maintenance, that was a case of them
Changing the conditions.
Putting something, yeah.
Yes,
Changing conditions.
if you're going to add something to a process or change a process, therefore, what do? You've got to do an assessment of the likely results that could occur.
So can I ask you this other question? In a workplace environment, employers have obviously got to do a risk assessment of everyone's tasks.
From a point
It's
of view of
required by the
manual handling,
occupational-
as I've
yeah.
indicated, and if you look at the occupational health and safety plant regulations and code of practice, that's a requirement in relation to guarding.
Okay.
So, look, there's consulting engineers and experts play a very important role in the court process.
Yes, they do.
And you're involved in conciliations and mediations as well, where matters settle out of court.
Yes, because the people who are undertaking the settlements must have the information to base their settlements upon.
Okay. Thanks very much, Richard. We'll having a short break, and we'll be back with Viv's mailbag after the break.
Thank you.
Thank you.